Oh gosh.
Okay, we're almost there. We're almost there. We are live on YouTube. All be famous.
Just one bar. There's a couple of them I like accidentally italicized thing. I was thinking two of them like were bio. That one was rough. This one was easy. I got all correct. And the first five was
Sorry, trying to put the camera in a place where I'll actually see what I need to be seeing.
It makes me feel productive when I'm like my brain's fried. Yeah, it's like I can't read, but this was a productive use of my brain.
Almost there.
So I did get that. Man, I can't read right now, so I just did those.
Well, it's the only reason we're doing this is because that multi-$1,000 camera at the back of the room no longer works. Nobody knows how to fix it. The microphones in the classroom no longer work, and nobody knows how to fix them. So yeah, we're back to doing what I was doing 15 years ago and using a portable webcam. All right, the MPT. You have this thing. You have this packet. This is an MPT, my friends, from a real actual bar exam from yesteryear. You're going to have this one that we're going to go through in class. I'm going to give you another one on Thursday, and if for some reason we don't have class, then I'll email it to you. And then you'll do the real one next week on Friday. It counts as a very small portion of your grade, but it's important that we start exposing you to these MPTs at an early stage because so far you don't believe it, but you have had the luxury of time to work on all these projects in LARW. And over the course of the next couple of years, you're going to have to get way faster because you're going to have to do essentially what was, these are roughly the equivalent of memo 1.1. So you got a couple of cases and you're going to write a memo or a brief or a letter. It's going to be a memo. So that's really the only thing you know how to write. And you only have 90 minutes to do the entire thing, right? From understanding the law to writing the entire thing and making it look like a memo. So let's just talk about how you're actually going to do that because it seems like a very daunting task. So it's the Murphy method for doing the MPT. There are lots of different approaches to the MPT. Mine is the best. Let me tell you why. Yesterday in my other class, I had 3 people who took the bar exam last summer come in and talk to people who are getting ready to take the bar exam this coming summer. And they said that, so the first thing you do on the bar exam is you have to do 2 of these back to back in 3 hours. And that when you go into the bar exam, you sit at a table with another person, and it's some stranger from some other law school, so it's not going to be anybody who knows something from tech or SMU or someplace like that. And all 3 of the panelists said that when they started, like within literally seconds or minutes of opening the packet, they actually started to type their answer, that the people all around them were freaking out because here's somebody who's already typing and like they weren't going to start typing for the first 45 minutes. And then when they walked out, they were also happy compared to the people from other schools who looked like their mother had just died because they had no idea how to approach this thing in 90 minutes. They had some idea, they just hadn't practiced enough, and they certainly didn't start in the 1 year. So this is why we do it this early, and this method, this will make you feel better on the exam day, I promise. So do it this way. So what is the MPT? It's part of the bar exam. It supposedly assesses time management because you got to get it done in 90 minutes. Whether you can write like a lawyer, whether you can turn out a product that looks like a memo, a letter, or a brief, including things like the memo heading and the to and the from and the subject line, all that stuff is going to look like something a lawyer would actually write. Can you follow instructions? This is huge on the MPT. There'll always be some little twist that makes this memo different from any memo you've ever written. And if you don't follow those instructions and do what they say, then you're going to lose points because they want to see who can actually read this stuff and understand what they're supposed to do. Jurisprudence, weight of authority. If you've got a case from one jurisdiction and a case from another jurisdiction, which one is going to be the most weighty in your jurisdiction? By the way, the MPT is always set in the fictional state of Franklin. And usually the cases that you get and the statutes that you get will be Franklin cases and statutes. Sometimes it will be a question of federal law, in which case you'll get a federal statute and some federal cases. When they do federal, it's usually real cases and real statutes. But if it's Franklin, it's just made up stuff. It could be anything. Just, because there's no state of Franklin, in case you didn't know. They're testing whether you can spot the issues. Do you understand what the issue is? Very much like you would on a law school exam. Can you synthesize rules? That whole rule synthesis thing. Typically fairly significant on the MPT, though often simpler than what we were doing last week and we'll be doing again later this week. Can you apply the rule to come up with a conclusion? And can you at least sprinkle a little bit of analogical reasoning into your answer? So you can say, oh, our case is just like that precedent case that you gave me, and I'm going to make that connection. You don't have to get into a lot of depth. It's not going to be like you were writing a memo for me under unlimited time. But you want to throw some analogies in there just to show you can do it. This is what the NCDE, alphabet soup, NCDE, NPT, multi-state performance test is what NPT stands for. And NCDE is the National Council of Bar Examiners. So the people who write the bar exam, this is what they claim the NPT is requiring you to do. Sort detailed factual materials and separate relevant from irrelevant facts. That's a big part of it. Though really there aren't that many irrelevant facts. Most of the facts you need to mention in your answer in some form or fashion, even if what you're saying is this fact doesn't change the answer because it's irrelevant. Analyze statutes, cases, administrative materials for principles of law. That means can you read a case, spot the rule, put the rule into your answer? That's what they're talking about there. Oh, can you read a statute? And if necessary, can you, remember what we did the very first week of law school? We were parsing those statutes into their component parts. Can you do that? Sometimes they do it for you. They'll say that the elements of this offense are 1, 2, 3, and 4, but sometimes it's just a sentence and you have to break it down into the component parts and figure out how to analyze each part of it. Can you apply the law to relevant facts in a manner likely to resolve a client's problem? It's application. Identify and resolve ethical dilemmas when present, almost never on the MPT, but if they give you a rule of professional responsibility, those black slides that I've been showing you that says a lawyer has a duty to do this, that, or the other thing, if they give you that kind of a rule, then there's an ethical problem that you have to talk about in your answer somehow. Communicate effectively in writing, like say clear writing, does it make sense? And then complete the lawyering task within time constraints. And really, this is the hard part. If at this stage I gave you a week to do this problem and write out a memo of say 1,600 words, it would not be a huge challenge for you. You'd be able to knock it out. But getting it done in 90 minutes, that's harder. The process is essentially going to be the same, but you're going to have to get a whole lot more efficient than you have been in the past. And I'm going to help you with that because that's what the Murphy method is all about. So on the MPT, you might have various tasks, persuasive, brief, objective memoranda. Those are the things that come up most often. And then letters to, so we've talked about most of this stuff already. Letters to opposing counsel, that would be a persuasive letter. Letter to your client, that's what you're writing tonight. That's an advisory letter or an opinion letter. And then some weird stuff occasionally, closing arguments, interrogatories, wills, and pleadings. The only ones you have to know how to do are these four. If on the bar exam, they throw you a curveball and they tell you to write interrogatories, there will be enough information in the packet that if you have no idea what an interrogatory is, you'll still be able to do it. Everybody will be in the same boat because people only practice these up here. And indeed, most people only practice that one, but you're going to be better prepared than that. This is how frequently things come up on the bar exam. So you can see that objective memorandum is by far and away the winner. It's usually a couple of memoranda is what you're going to be writing, or maybe a memorandum and a brief. And then letters after that. But the other things, these esoteric tasks, not even worth worrying about because they come up so infrequently. Sometimes you get a task within a task. So you're writing a memo, but as part of that memo, you have to draft something like an arbitration clause or revise an employee handbook, but it's all within the context of a memo. So how this comes up is they will, well, let's just take memo 3 as an example. They give you this crappy warranty disclaimer that's not conspicuous, and you have to redraft it in a way that makes it conspicuous. But that's all part of the memo where you're explaining why it didn't work the first time around and how you have to change it, what the law requires to make something conspicuous. So you could do that. That would just be like tacking on another little section to the memo that you wrote for memo 3. Sometimes you get a real curveball, like this one said to write a leave behind. That's what the assigning memo said to do. I had no idea what a leave behind was. And neither did anybody else. But that's okay, because the next page says, here's what a leave behind is. It's a memo that you leave with, that a lobbyist leaves with a legislator to persuade them to vote in favor of certain legislation. And it's just a persuasive memo that lays out all the pros and cons of this particular legislation. So there's a whole page that explained what it was and how to write one. And from there, it's just like writing a memo. Now you know what it is. So they'll always tell you what to do if it's something besides a memo, a letter, or a brief. But they assume you know how to write those 3 documents. Okay, they do make life difficult. The packet does come stapled like this. You'll see that there's a handy page of blank page at the end, so you can take notes. except you can't because you can't take the packet apart. You can't print this page out and use it to take notes. So the method that we're going to practice requires no note-taking at all. Indeed, when I've processed an MPT packet, there will be very few marks on any of the pages. Maybe a star here and there, a capital R for a rule that I'm not sure how it's going to fit in. Very little underlining, very little outlining. Everything is going directly into my document. And I'm going to show you how, because it's almost like magic.
You can take notes on your computer, though.
Hmm?
Like theoretically, you can use your computer for.
You'll be typing your answer on your computer, but they're going to give you the problem in a paper document like this, and you can't take it apart. But yes, the problem is you have no page except the answer page on which to take notes. Yeah, so I'll show you. It works out. Yeah.
Are we using Blue Book for those items?
Oh, EBB,
Or yeah,
Electronic Blue Book.
Yeah, whatever.
Yes. Yeah. For the one you're going to do in class next Friday, I think they are setting it up so that you'll use EBB to make it as much like the bar exam as possible. Yeah. Yes.
Do they expect citations?
Yes, but not full-blown citations because you won't have enough information to write a Blue Book compliant citation.
Is it just going to be our class taking the MPT, or is it like every writing class taking
Every writing class is doing. Some have already done it. They did it first thing in the semester,
Really?
which I think is kind of nuts. But yeah, most classes are doing it next Friday. Okay. This is how it's scored. Scaled on a score of 1 to 6. The graders who are reading these things put themselves in the mindset that they are your supervisor and you're a junior associate at a law firm. Okay. Or sometimes you're writing for a judge, so it might be a court, and they're the judge and you're the law clerk. And they graded on this scale of 1 to 6, where 6 is this is great. This is so good that I can sign this and send it out to the client or to the court without really any further modification. 4 average, it's going to require some guidance and you're going to have to revise the product. Below average, you're going to have to rewrite it. It's very unresponsive to the prompt, and you're going to need a lot of guidance and have to redo the whole thing. Number 1, this is so bad that they're not even going to ask you to redo it. I'm just going to do it myself. It'd be simpler if I just do it myself. Okay, to actually pass the bar exam, you're shooting for somewhere between a 3 and 4 on average between the 2 MPTs that you're going to write. All right, the higher the better, but this is the minimum threshold. No one has ever passed the bar exam from our law school if they got less than a 3.5 average on the MPTs. That's the threshold. So yeah, minimally acceptable to average. Can you do that? Hell yeah, you can. You're already doing it. You're above average, in my opinion, already. Getting it done in 90 minutes, challenge. Okay, these are the mistakes that people make on the MPT and how to avoid them. First, you write an answer that is incomplete, and that is usually a time management problem. Sometimes it's an editing problem, but that comes back to time management too. So the only way to get better at time on the MPT is to practice, and that's why we are starting now, even though you don't have to do it for the bar exam for another, 2 years and almost 2.5 years. This is what I'm going to suggest, and most of you are going to ignore me. But those who don't ignore me will have a better time in the summer of 2027 when you're studying for the bar exam, and it's this. We're going to do a few MPTs over the course of the next 10 days. Then you should continue to do MPTs at the rate of maybe 1 a semester, maybe 2 a semester, until you get to the 3rd year of law school, and you should do 1 every month. If you do that, and by the time you get to this point of your 3L year, you can be a superstar at the MPT. You can have that skill locked up for the bar exam and not really have to worry about it that much. If you end up taking my live section of the Preparing for the Bar course, assuming that we still have that course when you're a 3L, then we will focus very heavily on the MPTs to make you a superstar at the MPT by the time you graduate. So that when you graduate, you can focus on the other aspects of the bar exam. You still have to do MPTs, like a perishable skill, right? You have to keep that muscle flexed all the way through till exam day. But it will be cognitively less intensive if you already know how to do it. Okay, so time management, the only way to get better is to practice. We have a bank of MPTs. You actually have access to it and have since day 1. If you go to Canvas, you've got an academic support page in Canvas. If you go to that, you'll find a bunch of multiple choice practice questions. You'll find every essay question that's ever been on the bar exam that we could find, plus every MPT that's ever been on the bar exam. So if you're looking for additional practice between now and next week or after next week, because you're going to do what I just suggested, then that's where you will go to find those MPT prompts. Really, if you just do one once a semester, get together with your study group, your friends, your whole class if you want to, and just practice it so that you don't completely lose the skills that you're going to gain over the next 10 days. Okay, poorly organized answer. Think of the poor grader who has signed on to grade bar exams, and they get sent 500 to 1,000 MPTs. Think about that. Imagine grading hundreds of 1,600-word answers, and they're getting paid not by the hour. They're getting paid like, we're going to pay you this much money to grade this many essays. So their incentive is to get through them as quickly as possible. You will spend 90 minutes writing this document. They will spend 3 to 5 minutes tops, absolute tops, grading it. I can grade an MPT in 3 minutes. I can grade it in 2 minutes if I don't have to make any comments. If I have to make comments, then it's going to take me about 15 minutes. But they get through these things extremely quickly. Organization is absolutely paramount on the MPT, because if you write a document that makes it difficult for the grader to find those 3 or 4 things they really want to see how you handled out of the 10 that you had to talk about, if they're struggling to find that, they are not going to slow down. They're just going to assume that you didn't do it, and your score is going to suffer as a result. So structure is huge, and we're going to talk about how you figure out what the structure should be. What you're going to do is you're going to look at the assigning memo. It's going to tell you what the structure should be. And if you don't get any clues there, then you're going to look at the rules, and the rules will tell you what the structure should be. Like it's a 3-element test. You're going to have 1 section per element, exactly the way you've been writing memos so far in this class. So poorly organized work is really going to hurt you. Doesn't look like a document a lawyer would write. They ask for a memo and you give them a letter. They ask for a letter and you give them a memo. They ask for a brief and you give them who knows what it is. They ask for a persuasive brief and you're using words like probably, a court will probably rule in favor of. No, that's not persuasive. That's memo stuff, right? So give them the document that they're asking for. What do you know how to write so far? You know how to write letters. Oh, sorry, you know how to write memos, and you've seen a letter, but you don't really know how to write those. So I'm going to test you on memos when we do this next week. My philosophy on the MPT is don't panic, don't panic, don't panic. Panic's just going to eat into the 90 minutes you have available to do this task. You need a plan. It's going to work for every MPT, but regardless of what kind of curveball they throw to you. And my method works for every MPT. If you do these steps, it's going to be okay. Once you have hit on the plan that you're going to use, I recommend mine, don't change it, keep practicing that. And if you decide you're going to do something else because my method doesn't work for you, then practice it repeatedly in anticipation of the bar exam. And I would say practice it repeatedly in anticipation of next week, but you're not going to have time to come up with your own method in 10 days. These are the main things that separate my method from others. We're going to read everything once, and only once if possible. So you're going to read a case. You're not going to read that case 3 times like you would for writing a real memo. You're going to read that case once and get out of it what you can in that single read through. If it's a statute, you're going to read that statute 1 time. You're going to get everything out of that statute the first time through. This works most of the time. It takes some discipline. And sometimes you do have to go back and look at the legal materials again or the factual materials again. But ideally, we're going to read everything 1 time. And then we're going to be typing as we go. So when you find a rule, you're going to put it into your answer. When you find a fact that correlates with that rule, you're going to put it into your answer. Later, you can come back and write your applications that tie those 2 things together to reach a conclusion. But here's the metaphor that I frequently use. It's a terrible metaphor. You need to come up with a better one. It's like an Easter egg hunt. So you're going to have this packet that has factual materials and legal materials, and they're all kind of jumbled together. Like the facts are not presented in a nice linear fashion. It's like, let's talk about this and talk about this, and here's a letter or a contract that's talking about some other thing. And your job is to sort all those facts out so that you're talking about the right facts in connection with the right element or factor or part of the test, whatever it is. So I think of the parts of the test, they're like Easter baskets, and the Easter eggs are the facts. And what you're trying to do is once you figure it out, like, oh, I've got these 3 elements that I have to talk about. Those are your Easter baskets. Let's say you've got a blue one, a red one, and a yellow one. Those are your baskets. Or it's not a good, because that's how Easter egg contract work, right? But then you're finding these eggs. Oh, I found a blue egg. It goes into the blue basket. I found a red egg. It goes into the red. It goes into the blue one. Goes into the blue basket. Yellow one goes into the yellow basket. As you're going through the facts, you're sorting them out into their relative baskets. That way, by the time you get to the point where you've read everything that's in the packet, you have everything sorted out into your memo. You haven't probably written many sentences yet, but you at least have the facts listed where they're going to go into your memo. And you just turn them into sentences, and then you're done. I'll show you what that means. Type as you go, though. It's hugely important. As soon as we find out that we're writing a memo, we're going to start the memo heading, the to, from, and subject, the date, all that, get all that on the page because we know it's a memo. As soon as we know, oh, there are these 3 questions that I have to answer, I'm going to put those 3 questions into my answer as headings. And when I find that that first question involves a rule that has 3 elements, I'm going to put those elements in as subheadings, right? I'm building the structure as I go. I'm not waiting until I've read everything to figure out how I'm going to put it together. I'm just going to build it as I go through it. It's like magic. Okay, tips. Follow the instructions carefully. We'll look at some instructions here in a minute. Use enumeration. Enumerate your questions. If they ask 3 questions, but they're just bullet pointed in the assignment memo, put a 1, 2, and 3 in front of them. It helps. If you have a statute that uses enumeration, copy it exactly with the enumeration and then use that enumeration to structure your answer. If it's not broken down for you and enumerated, like they just give you a sentence long type rule with a bunch of elements lumped into it, break it down and enumerate it in your rule statement, and then use that as the structure for your discussion. Yeah, separate paragraphs for each one of those numbers. Okay, here's how we're actually going to go through and process. These are the steps to getting this done in 90 minutes. So let's just take a look at the MPT packet and see what parts are in here, because they're all laid out the same way. Sometimes you'll have a table of contents and sometimes you won't. You can just ignore them. I mean, if you have it, you'll look at it just to see, all right, how many cases do I have? Do I have a statute? This one just has 2 cases, so relatively straightforward, or so it seems. And then the next thing is going to be the file. So the MPT is divided up into 2 main parts. One is the file that contains all the factual documents, and the other is the library, and that contains all of the legal documents. So if you've got statutes, rules, cases, whatever, they'll be in the library. Everything else is going to be in the file. So the first thing that we're going to look at when we open the file is, well, we'll look at the table of contents. If there is one, but they don't all have that, so we're just going to skip that step. So we already looked at it. You're going to look at the first page of the file. The first page of the file is always going to be the assigning memo. Very much like the assigning memos that I've given you for the projects that you've worked on for memo 1, 2, and 3. It tells you what it is you're supposed to be doing and gives you some important clues as to what you're writing about, what the factual background is, very much like the assigning memos that we've had in this class. So you're going to study this quite carefully. So let's go ahead and take a minute to read through this and see what it is. So we know from the subject line that it's Roberts and she's our client, says in the first sentence, and that the other party's JBL Builders. So they bought the lot behind her. Now they're dumping dirt there. It's making her life miserable. They refuse to fix it. Okay, then we get down to that next to the last paragraph. This is the important part. We're considering asking the court for a preliminary injunction. And then the instruction is, please write an objective memo that determines whether a court is likely to grant a preliminary injunction. Omit the question presented, short answer, and statement of fact sections. Use appropriate headings and subheadings to make your memo reader-friendly. Very typical instructions for the MPT. So as soon as we read that paragraph, we know that we're writing a memo. And at that stage, I would immediately start typing the memo heading just to get it out there on the page. The word memorandum in the middle of the page, the to, from, and subject line. The MPT is always from applicant. So you would write from applicant and not use your actual name. It's usually going to be to the person who sent you the assigning memo. So ours is going to be to Hugh Dewey. And then the subject line, just copy it. You're not going to get any points for a fancy subject line like I require you to write, so just use the one that they gave you. Okay, yes?
Is this going to be in the blue book, like an online thingy where it's really hard to format?
EBB, yes.
Yeah, that may be.
That's okay. Formatting doesn't matter. Like if everything is just justified in the left margin and you're not centering anything and your lines don't line up after the subject line like I tell you to, don't worry about that. That doesn't count. As long as it looks like a memo, you're okay. But you're going to find that you are able to center and yeah, you can make it look pretty much like the memos that you've been writing using EBB. Yes?
And to make the horizontal line, we just do a bunch of underscores.
You don't
all
have
the
to
way
worry
through.
about that.
Okay.
Yeah, just doing what you can. But you could, yes, you could underscore all the way across if you wanted to, but I wouldn't be too concerned about that. Okay, so we're writing an objective memo and it determines whether court is likely to grant a preliminary injunction. I'd probably put a star by that because this is the most important thing on this page, that its preliminary injunction is the thing that I'm supposed to analyze. This is called the task statement. And just you're going to look at it a couple of times while we're processing the MPT to make sure that you are still on track. It's easy to drift away from what the actual assignment is if you're not referring back to this occasionally, a couple of times while you're writing. Okay, it says to omit the question presented, short answer, and statement of facts. That's true on just about every memo NPT. You will not include those parts of the document. Instead, what you're really writing is just the discussion section. You don't have to have the word discussion at the top of the page, but if you're leaving all those things out, that's the only thing that's left, right? Use appropriate headings and subheadings to make your memo reader-friendly. Even if it didn't say to use subheadings, you're going to put those subheadings in. Because why?
Make the organization easier.
To help the grader in a hurry find what the grader is looking for. Because the grader, if there's some gimme issues in almost every NPT, right? It's easy, doesn't really require any analysis, it's so clear. They're probably not going to read those. They're going to read the ones that actually require some intricate analysis. So make it easier for them to find those things. Okay, if this said to write a brief, then the second page of the packet would be instructions for how to format a brief. On the NPT, they have very specific heading instructions for briefs, not for memos. For the memo, you can structure the heading however you want. But for a brief, they would say the heading has to be just like this, and you would do it. Okay, we're not writing a brief, so we're not going to worry about that. But just keep that in mind for a couple of years down the road. Okay, that's it. I think we've gotten everything out of this assigning memo that we needed to get. A little bit of background facts. We can use those facts if we need to later. We're going to come back to this document again, so we don't have to write any of that down. But we know we're supposed to write a memo, and we started our document. And this is what was freaking other people out at the bar exam last year. The students had 2 memos, and as soon as they saw it was a memo, they started typing that memo stuff just to get it out of the way so they don't have to worry about it later. And that was freaking out the people who were sitting around them, and that's good. I want people from other schools to be freaked out during the bar exam and our students to be confident. Okay, skim the file. We're not actually going to read any of the rest of the file now. We have to flip past it to get to the library. So as we're flipping past, just see what we've got. Okay, we've got an affidavit, looks like. That's a statement of facts from our client, signed by our client. And then we've got another affidavit from somebody else. And then we've got, looks like a newspaper article. And that's it. I'm not reading any of these things, just I have to flip past them. So I might as well just see what they are so I can start getting that into my head. But now we're going to stop at the library because this is where the legal rules are. Now, this is important. It's counterintuitive. If I gave this to you and told you to process it, and I didn't give you any help or instructions, you would almost certainly read the file first and try to memorize the facts, or at least get some idea of what the facts are. And then you would go and study the law. Because on an intuitive level, that makes sense, right? Tell me the facts before you try to make me learn the law. But it's not the most efficient way to process an NPT. And you're not going to believe me, and you're going to struggle with this the first time you do it. But I want you to skip the file except for the assigning memo, and I want you to go directly to the library. And here's the theory, and this is why it works. And by the way, every NPT method that you're going to find says skip the file and go directly to the library to learn the law. It's because the law is going to give you the structural framework that you need to understand the facts. And until you have that structural framework, you are wasting your time by trying to absorb the facts. So go and get your head around the law first, figure out what's important, what's not important, what am I looking for as I go through the facts, get all that into your answer, then go through the facts. You can do that Easter egg sorting thing that I was talking about where you're putting the facts into the relevant baskets. Okay, so we skim the file, just get past it. We get to the library. Now we get to the library. What we're really doing in the library is we are looking for rules. What is the answer that we're supposed to be, or what is the question we're supposed to answer? What does it take to get a temporary injunction? And what was the context of that temporary injunction? You get injunctions for all kinds of things. What kind of nuisance? Private nuisance. So the 2 rules we're looking for are, how do you get an injunction, and how do you get an injunction for private nuisance, or what are the elements of private nuisance? So when you're reading through the packet, that's what you're going to look for. Now, we don't have any statute here. It jumps right into the cases, so we know this is going to be a common law doctrine. When we read the cases, we're going to be looking for the rules that are going to answer those questions. Now, the assigning memo did not give us, it did not break the task down to us. Sometimes the assigning memo is going to have multiple questions in it, like answer these 3 questions, or it will have some very specific formatting instruction, like put all the rules into this part and put all the application into this part instead of combining it into a single section the way you've learned to do React. Just some weird stuff like that. Remember I said they'll throw in those weird instructions to see who's paying attention. This one didn't really have any weird instructions, but it didn't give us a whole lot of help in terms of what the structure is going to be. So we have to look to the library to find the structure. We're going to find the structure in the rules, and the rules we're looking for are preliminary injunction and private nuisance. So we start with this first case. Let's look at the case. This is Parker v. Blue Ridge Farms, Franklin Supreme Court, 2016. Note that there's not enough information here to write a Blue Book compliant citation. So if we were going to cite this case, and we will throw some citations in there just to show we know where they belong, we'd simply say Parker v. Blue Ridge, Prinz, FR 2016, and that would be sufficient. If you don't have time to do that because you're a slow typist like I am, then you can just put Parker period, and that would probably be sufficient. It would be sufficient. Just, you know, they want to see, can you put the citations in the right place, not can you write something that looks Blue Book compliant when you don't have enough information, right? There's no reporter, volume, or page information. Yes?
What if it's subjective, if it's an element or factors test?
Subjective as to which one it is?
Yeah.
Yeah, on the MPT, it's going to be relatively clear. I mean, I'm going to say it's going to be crystal clear because either it's an elements test or a court is going to call it a factors test. And say the factors are, and you know, yeah. I've never had an MPT where I struggled to figure out are these elements or factors. It's pretty clear. Okay, so when you're processing the cases, I just start reading from the top and go to the end. There's a little trick that you can sometimes do, which is read the last paragraph of the case, but that works only about 50% of the time, so I'm not going to do that. When you get to actual bar prep, your bar prep company might say start at the back of the library and read the newest case because they're listed in chronological order. Read the newest case and work your way backwards. That also works only 50% of the time, so we're not going to do that either. We're just going to start reading with the first case and extract out of it what we can. Okay, so what is this case about?
Private nuisance.
Private nuisance. Oh, hey, isn't that what we were looking for? The rule of private nuisance? Okay, so yes, this is going to be our private nuisance case, apparently. Does it say anything about injunctions in that first paragraph?
No.
No, this is apparently not the injunction case. So what we're looking for is, well, we get down to the third paragraph and it says they are suing for injunctive relief, so there might be something in there. But their claim is based on common law private nuisance. Hey, ding, 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 that's the rule we're looking for. But where's the actual rule? I'm skimming, I'm skimming, I'm skimming.
Second page.
Second page, good, where is it?
First full paragraph.
A private nuisance is a non-trescatory invasion of another's interest in private use and enjoyment of land. The essence of I could copy this paragraph directly into my answer. Look, I said I don't put many marks into my answer, but I'm going to put a big R here because this is one of the main rules that I was looking for, just in case I need to come back and look at it again later. But now that I found it and I know that private nuisance is a rule that I'm looking for, I'm just going to copy this entire paragraph. I'm going to leave out all the internal citations. And I'm not worried a bit about plagiarism. I'm going to copy it exactly the way it is. On the MPT, on the bar exam, there is no plagiarism on the bar exam. Like you can copy directly from sources into your answer, it's absolutely fine. Don't worry about putting quotation marks around things because nobody's going to bust you for plagiarism on the bar exam. They just don't care. Copy this text exactly into your answer. And look, lo and behold, it's broken into elements there at the end. So what do we have? We've got background rule, more background rule, and then we have to recover damages in common law private nuisance cause of action. You have to prove these. How many elements are there? Three elements. Okay, this is going directly into my answer as the rule statement for private nuisance. But then this is the trick. You ready for this? I'm immediately going to copy that rule statement that has the 3 elements in it and paste it. So I've got the rule statement in there twice.
Oh, so you have it for the next part.
No, so and then I'm going to, after each element in the second part, I'm going to put in a couple of line returns. Because what do I have now? I've got a rule statement and then I've got automatic headings for each one of those elements. And how long did that take me? Seconds. Type this, copy it, paste it. You understand what I'm saying? So after I've got the rule statement all together as a block, and then I've got one line for each element. Those lines are now my headings for the rest of the analysis on private nuisance. Pretty cool, huh? Yeah, that's how you get this done quickly. Zach, get your hand up.
So I just want to clarify what you're saying. The entire paragraph, including the helper rules and the stuff like that, is the rule statement, and then you type, starting at 1, the defendant's conduct below, you type that again and then make those the headers.
Wait, the defendant, but was it?
That was the start of the first element. That's where you start typing it again for the headers.
Yeah, exactly.
Okay.
Or copy and paste. I'm not going to type it again. I'm going to copy and paste so I don't have to type it. Yeah. Okay, good. Yes, that's exactly right. So the first, you're going to have that whole rule statement, and the first heading is going to be the defendant's conduct was the proximate cause 2 of an unreasonable interference. Yeah. Okay. All right, good. So we've got our rule statement in. Look at that. You would be, what, 3 or 4 minutes into this, and you've already got one of your major rule statements into your answer, plus a bunch of headings. Okay, now we keep on grinding through this case because now it says in applying element 2, the reasonableness of the interference with the plaintiff's use, to remind you what that element was, even though it was in the line immediately prior, the fact finder should consider all relevant
Factors.
ding, ding, ding factors. So what do we have here?
Factors test.
We have an elements test, and the second element comprises these factors. So now I'm going to do the same thing. We've got our headings in here, right? So now I can drop down to my second heading, and I can take this entire paragraph and paste it in there, copy it in there rather. Then what am I going to do next?
I'm going to copy and paste.
I'm going to copy it and paste it, and then I'm going to hit return. So now I've got my elements headings, and then under that second element, I've got my factors test, and then my factors headings. Isn't this cool? It is, yes. You know how long it took me to come up with this?
For the main rule, we do include like the background rules, right?
For the, I'm sorry, for the
main rule.
main rule, I thought you said main. For the main rule, yes.
We include the background rules.
I would just copy this whole paragraph. How long is it going to take you to type that? If you're a slow typist and you can only type part of this, then the part you absolutely must have is the part that says to recover damages in a common law private nuisance cause of action. Right? That part you absolutely must have. I would say the rest of that paragraph that comes before that is optional, but I'd put it in. Yes.
I know for like other exams, the spelling doesn't matter, but for this it does, right? Like having perfect grammar and spelling.
It doesn't have to be perfect. The sentences do have to be complete. You don't want incomplete sentences, but if your spelling is off, that's okay. They understand this was written under extreme time constraints with crappy exam time software. But yeah, when we get to the end, the last step is going to be try and have 5 minutes where you can go through and check your spelling and make sure your sentences are all complete and you didn't leave stuff hanging. Yes.
So for the rule statements, we don't, so I know you said when it comes to, when you're citing the cases directly, you just kind of want to have like a little tidbit, but if it's not the case, if it's like all the restatement stuff in here, you want us to completely omit all of it?
All of the citations, right? What am I going to cite for all of that stuff?
Restatement.
Parker. I'm just going to cite Parker, right? Because remember, once a jurisdiction has adopted the restatement, you don't cite the restatement anymore. Now you're citing the case that adopted the restatement because it's the law in your jurisdiction. So I'm just going to cite Parker. And yes, the first time I would just say Parker, and then all of these others are going to be it. That's it. Even if I'm probably just going to leave the ids out. If you've got some citations in there to show where the rule came from, that's all. That's all you need. Yes?
Is there a word count limit?
There's not a word count limit, but let's go ahead and talk about this. And that is, how many words are you shooting for? I've seen some 800-word answers that were quite good. Every word counted, and it was perfectly organized, and there was no fluff. It's probably not going to get a 6 because it's a little bit too short, but it might get a 5 out of 6. I have seen some 2,400 words that were absolute garbage, and they're going to get a 1. Think about that. 3 times, 4 times as long, and it's much, much worse. And why do you suppose that is?
Hard to find the relevant information for the grade.
Anybody who's typing that fast is probably just vomiting words onto the page. They're not actually thinking about what they're writing. So what is the Goldilocks zone? 1,200 to 1,600 words is what you're shooting for. 1,260. If it's more than 1,600 words, and I start to wonder, were you really thinking, or were you just, copying stuff willy-nilly onto the page? And that's usually what happens. So yeah, shoot for 12 to 16. And you can go shorter. You can go shorter and still be okay. You can go longer and it'll still be okay, but it's probably not going to be as good as if you're in that Goldilocks range. Yes.
So if we're given case law like this, is there ever instances where one of the cases is actually like overturning the other case and we don't? Because
there's usually not that level of stuff going on. I'm trying to think, are there any where there are actually conflicts? Like you might have cases from different jurisdictions. That does happen occasionally. And you have to know enough that the case from Franklin is the one you should be applying. And the other case is merely going to be persuasive. That doesn't come up very often.
okay.
Mostly you can just take the cases and apply them at their face value. But there's a statute involved that's sometimes a little trickier, but I'll talk about that next time. Yes.
When there's grading, I know you said it's 1 to 6. Is there ever like a half, or 3.5, or is it just?
Yeah, they give half points.
Oh, okay.
But that's as small as it gets. I sometimes give quarter points, but I've never seen quarter points on an actual bar exam.
This is nitpicky, but do you have to italicize your citation?
Nope. We're just throwing something in, looks kind of like a citation, and that's good enough. All right, we are actually out of time. So what I want you to do for Thursday is I want you to, you don't really have to scrutinize it closely, but if you read the cases and you read through the facts, then we'll be able to move more quickly because we'll all know what the elements are. We'll know what the other case is talking about. We'll actually be able to put together something that looks reasonably like an answer in the amount of time we have, yes.
Do you want us to try to answer it or just?
No, I'm gonna have another one for you that you're actually gonna try and answer. This one, we're gonna walk through together. And then if you wanna write an answer after that, that's fine, but you'll have another one to work on at that point, so I do that one instead. Yeah.
In the event of weather, will you be communicating like your year into like we still have class?
I don't know. Stay tuned. I have before. Indeed, I have a whole video on how to do an MPT. It's 2.5 hours long because there was a snow day and I couldn't come to class and I needed to talk about it. So I just sat down in front of my computer and I did the whole thing soup to nuts. And that's how long it takes me to explain and walk through an MPT. So I could do the same thing again. It's probably time I updated that video anyway. It's not been a couple of years. But I would prefer not to do that. I hate talking to the camera where it's just me. Anybody listening? Probably not.
We could do a Zoom call.
We could it's
I can show you my dog.
did we learn nothing from the pandemic? That Zoom learning is not learning.
It's not good.
It's not learning.
Hey, just take a day off, guys. We don't have to do philosophy there.
That's kind of how there are tricks for. You can also just be on a different tab on your computer. It looks